Ms. King?
You're having quite a day.
I certainly am. Good morning. May it please the court. Michelle King, Assistant District Attorney for the Commonwealth. This case raises, at least in part, some overlapping issues from the previous case. It will raise the issue of relevancy that we weren't talking about in my first case. The issue here is whether or not there was an abuse of discretion when the trial judge ordered the Commonwealth to produce, by way of Rule 14, police reports from a particular trooper over a 7-month period that included the time period when the defendant was stopped, without any sort of showing whatsoever by the defendant in the trial court of materiality, relevancy, or even possibly exculpatory nature. Basically, defendant walked into court, into the Superior Court, with a motion that said, I want the police reports, and the Superior Court judge said, okay. No showing. In fact...
Former prosecutor, by the way.
Excuse me?
Wasn't he a former prosecutor?
I believe so, actually. He was from the appellate division of... in fact, his order, Your Honors, noted that the defendant did not state in his motion why he was requesting the documents. Everybody sort of assumed that it was for Fourth Amendment purposes, as did the single justice when she denied the Commonwealth's petition. She said the defendant apparently seeks the reports here to raise the issue of whether or not the motor vehicle stops are done on a discriminatory basis. But there was no showing anywhere why the defendant wanted the reports, that they were material in any regard, relevant in any regard, or might possibly provide anything that was exculpatory in nature. I would suggest to you that...
Let me ask you this. Let's say, supposing all of that was simply not true, that there was that the defendant came in and said exactly what he wanted to use it for and why, and that it was rooted in constitutional principles. Did the defendant establish any basis to believe that the particular evidence was in fact the evidence? I'm not saying the type of evidence, but that the numbers were there. Did the defendant establish some basis for believing that there was a basis for thinking that there had been some racial motivations to the steps?
Well, there was nothing established, Your Honor, because nothing was said. He didn't say why he wanted them. He didn't come in with any statistics. He didn't come in with anything. There was simply nothing said as to why. There was no real hearing on the matter. Nothing was produced that said, I can possibly show that if I have these police reports. Exactly, Your Honor. And that's
King, let me ask you this, and it may not be relevant, but frequently in the civil context, an individual of a protected group is treated in a way that he or she views as negative, and essentially makes that allegation. And then, provided that the documents in the custody control, typically I'm thinking of employment cases again, the employer has to hand over information. You don't have to make a claim at the beginning that I know what the data is. The claim is, if I had an opportunity to look at the data, I think I could substantiate. And sometimes it's because, I've seen other, women, minorities, whatever it is, treated. Why would we give greater protection to people in a civil context than we would in a criminal context?
Well, Your Honor, it's clear, at least in the criminal context, that the rule is very clear what the defendant has to make out in terms of making a claim for selective prosecution. First off, the defendant has to be able to show that a broader class of individuals who are similarly situated weren't prosecuted in the same way that he or she was prosecuted. In addition, the defendant has to be able to show that the failure to prosecute that group of people was consistent or deliberate.
I understand that at least one justice has expressed the view that being stopped isn't necessarily the same as being prosecuted. But let's assume that for purposes of my question, you do not assume that being stopped is the same as being prosecuted.
Well, I think.
And I understand the Franklin rule, and I understand the selective prosecution rules, at least as articulated by the United States Supreme Court. That you would have to show that there was somebody over there that had done exactly the same thing and was not prosecuted.
Well, I think the documents in question, Your Honor, have to have some sort of relevancy to the case, and they have to be material. And so the question
Right.
here is what makes them relevant. Now, if you look at any of the cases where the court has said the Commonwealth has to produce police reports or witness statements or lab reports, they all relate to the case at hand. I found no case, and the defendant has cited none, for the proposition that the defendant is entitled to police reports from entirely unrelated cases. In fact, 2 cases that I found from other jurisdictions said just the opposite. In those 2 cases, the first one was Vasquez Garza v. State. That was a Texas case. There, the defendant was trying to get some police reports held by a particular officer on an unrelated case to show his bias in that case. And the court said, no, it's not relevant to your case, any particular bias.
But relevance can be shown. I mean, relevance can be shown. I mean, that's the whole point of U.S. versus Armstrong. In order to get evidence tending to show the existence of selective enforcement, the defendant has to produce some evidence that similarly situated individuals were not prosecuted. The question is, how much is some?
Right. Well, here the defendant produced none.
But
Can
so
I-
it may not be relevant without a showing of specific relevance, but it doesn't mean it's not
Well, I
relevant.
think the issue is what is it relevant to, Your Honor? So the court in the United States v. Wren said for Fourth Amendment purposes, if you're
But it's relevant to selective prosecution. And if we conclude that what we're talking about here is selective prosecution, and in this context it would be selective arrest or stopping for traffic violations, then it seems to me perfectly relevant.
Well, I don't believe so, Your Honor, because again, in terms of selective prosecution in the stop itself, you would have to show that a broader class of individuals who were committing that same crime or that same offense were not stopped.
Correct.
The
I agree.
defendant is simply unable to do that regardless of this information.
Can I just follow up on a different question?
Absolutely.
We have before us the single justices order, correct?
Correct.
Does it change your argument if you look at what the standard of review here is? Because her conclusion was that the reports the defendants seek may provide at least a preliminary basis for him to establish the proposition that the motor vehicle stops are made on a discriminatory basis. Is that...
Well, it doesn't, Your Honor, because again, she's basing that on completely nothing. She is assuming, and she says, apparently seeks to raise. She has no idea why the defendant is raising it. There's been no offer of proof whatsoever. So she's basing a decision on what she thinks might be the intentions or the reasons that the defendant is seeking this material. So the fact that
Saying that after examination of these records that the defendant may find information that's relevant to selective prosecution?
well, I think that is what she's trying to say, Your Honor. But again, I believe that the case law is rather clear that it's the defendant's burden.
From your point of view, which you tried to articulate in the last case, but maybe because of the narrow procedural scope of the last case, we won't get to it, that if this is the kind of showing you make, namely you just come in and say, I want to get this stuff because I think I can show down the road there might be some selective arrests here or stops or tickets or whatever you want to call it, then every single case involving a minority or a Hispanic or racial or Hispanic case, ethnic case, there was in Holyoke or Springfield or Lowell or New Bedford, they're going to come in and want this. It'll be a standard motion.
Exactly, Your Honor, and that's precisely what it's turned into, at least
And
in
the
Worcester
courts
County,
will
is
grind
that
to a halt because if it's produced, it'll take months and months and months and months and months to have it analyzed and so forth. Then there'll be motions for costs to retain experts, and
it's not to say that if there's racial profiling going on that there shouldn't be some way of getting to the bottom of it. But again, these motions are.
What way would that be?
Well, I think the way that New Jersey did it is a perfect example of the proper way to go about it, and Justice Cordy mentioned that in the Laura case.
Yeah, but isn't that putting the cart before the horse? Shouldn't we be applying the Lampron standard here or the Rule 17 standard here? You're trying to subpoena third-party records, or you're trying to subpoena records in somebody else's cases to establish a particular point, don't you have to make some kind of or doesn't the defendant have to make some kind of showing? Not prove the case, but just make some showing that there's reason to believe that this evidence does exist.
Well, again, in the court, in the Wayness decision, said that...
Can you just answer Justice Spina's question, which is one I was going to answer? Is it the Commonwealth's position that Lampron should apply here? It wouldn't typically apply here if you were just asking for the file in the defendant's case, I thought was the import of his question.
Yeah, you're looking for third-party records. You're not looking for records in the defendant's case.
Well, the defendant is looking for them.
The defendant is looking for them. He's looking for records in somebody else's case. This is sort of like the sexual abuse thing. There's a witness out there, and we use the Lampron standard to get the private witness's medical records or psychiatric records. But the Lampron standard has to be followed, the Rule 17 standard.
Well, and this court said in the Wayness case, that case involved internal affairs records from the police department, and the court there said that, it wasn't the prosecution's burden to produce those, that in fact that the proper method of doing that was a Rule 17 motion in subpoenaing the third party. And I would suggest to you that that's exactly the proper procedure here. The burden should not be on the Commonwealth to have to
I know
produce
you've just said that, but why? Why? Because here, it strikes me that that's a possible argument, but it's not a third party. In other words, the Commonwealth, this is discovery from the Commonwealth.
Well, except that, Your Honor, every piece of information, every document that the police department is in possession of, the Commonwealth doesn't have access to. And if you look at the Wayness case, that's a perfect example. That document was certainly contained at the police department, and the court there said that no, that's not something that the Commonwealth has to produce.
Isn't the distinction, it's really the case. In other words, whatever the police department has that's relevant to that's connected to this case, this prosecution, you would agree, you are responsible for getting. But once you move to other cases or a larger universe of documents, even though it's in the same police department, that's where you would draw the line, is it not?
And I think the line of cases are very specific about that. When you're talking about witness statements, police reports, anything of the nature that is relative to your case, relates to your case, that's discoverable. There's no question about that. I'm not making that argument. But when you're talking about any police report contained at the police department having absolutely no relevance to the case,
Well, it's not the relevance. It's just that it wasn't generated in relation to your case. Whether it's relevant or not is the issue. But
right.
So who should the subpoena be served on, or the motion for the subpoena?
I would
be served
assume
on?
the police department where the police reports are.
So if the defendant had filed a motion for a subpoena of records in the custody of the Department of Public Safety, the state police, that would be appropriate.
I think that would be appropriate, and then the state police department would come in with their lawyers and state all the reasons why they felt that motion should be quashed, but that would have nothing to do with the Commonwealth and the prosecution team.
We made it clear that the Commonwealth can in fact participate.
Right,
I mean,
can participate, but
Sure.
again, the burden is not on the Commonwealth to produce it. If there are no further
well,
questions,
that's a somewhat different issue.
I'll rest on my brief. Thank you, Your Honors.
Thank you, Ms. King. Ms. Feldman-Rumpler?
Good morning, Your Honors. Leslie Feldman-Rumpler for Nathaniel Betances. I would like to start by clarifying a couple of points from the record. Firstly, the defendant did not simply walk into court and say, give me these records, without a hearing. There was a hearing. It appears from the record, and I refer to record page 14 in my brief, that there was a hearing on May 24th, after which the defendant filed a clarification. Then the Commonwealth filed an opposition. After the hearing, Commonwealth filed an opposition to the motion, after which the defendant filed a response. And in the defendant's response, he made very clear that the issue here is racial profiling, that he wished to make an equal protection argument. This wasn't guesswork on the part of the single justice. It was filed, it was on the record, it was argued, and it did happen.
Did you have any kind of preliminary data to support your request or motion that profiling was going on?
The motion was actually filed by trial counsel pursuant, citing Commonwealth versus Laura, which at that time was only a Superior Court decision, which contains statistics. in addition citing Commonwealth versus Gonzalez. And
Laura, which was argued today, doesn't hold up.
that's correct. If
That
Laura,
prop is gone.
if Laura doesn't hold up today, the fact remains that at the time, that was cited by the defendant's motion, again, signaling what the purpose of the motion was. I would actually point out that in the New Jersey cases, which have sort of been clumped together,
This isn't the same trooper, is it?
No.
it's
No.
not the same trooper as
So,
in Laura.
well,
A lot has been said today about the New Jersey approach, and I would like to address that. First of all, in New Jersey, the Attorney General came out and openly acknowledged there is a problem with racial profiling, particularly on the New Jersey Turnpike and the surrounding roads. There was an order issued by the New Jersey Supreme Court which essentially said any person who is or appears to be African American or Hispanic or otherwise minority who is stopped on these roads basically can go file a motion, and I'm designating a judge to handle these motions. So it was a different scenario in New Jersey, but in State versus Lee, the New Jersey Supreme Court, and I don't believe it is cited in my brief, but I can give you the site. It's 920 Atlantic 2nd 80. It's a New Jersey Supreme Court decision from 2007. It actually talks about post-conviction discovery requests. And the request concerned in that case concerned a situation where a motorist with a passenger was stopped. Both tried to escape after the stop, and the motion judge, who had been designated to hear all of these racial profiling discovery motions, said, I'm not going to give you the discovery because of the attenuation doctrine. The wrongful conduct of the driver and the passenger after the stop cuts off any wrong that may have occurred before the stop. I'm not going to give it
if
to you.
we take Laura out of this case, Laura, what basis do you have to get this information?
Well, firstly, you've got the defendant's state trooper report and the other two reports that he submitted with his motion, which were reports written by the same state trooper when he stopped other minority drivers on the very same road in the very same town. And if you look at those reports, they very closely resemble each other. In each report and in each instance, the driver is driving approximately 1/2 vehicle length and 1 vehicle length behind another vehicle for approximately a half a mile or approximately 1 mile. In one situation, this state trooper stopped a minority driver simply because the driver was in the left lane with access to the middle lane. That's
So
it.
you're suggesting that there's a kind of pattern of evidence which in a civil context gives rise to being able to get further discovery.
Well, actually, in a civil context, you wouldn't need anything. You would simply file a complaint and then file a discovery request, and you would get the discovery. But yes, I'm suggesting that there's a pattern, that the defendant did submit some evidence
How
in
did you
support
get
of his...
those other citations?
I was not trial counsel, and I don't know how he got them.
You get two
But-
police reports.
3 police reports,
Three
one
police
of Mr.
reports.
Betances and 2 other ones.
But there could be
That's
hundreds-
correct.
But there's nothing in there suggesting anything other than that they were similar arrests.
That's right. There's
They're
similar
there
arrests.
for pattern. That's what they're trying to establish.
Right. In other words,
There
what
could
he's
be,
doing,
for all we know, there could be hundreds of them.
there could be hundreds of them, and what he's doing...
97 others that are of white drivers.
Yes, but
There
that's
could
what the
and there
discovery's
couldn't.
for.
That's useful information that the defendant is trying to obtain. What I'm suggesting here is, firstly, this is really a case about the discretion of the trial judge to enter an order, and unless the trial judge did something so completely beyond his discretion that
That's
it was
true, but
beyond the bounds.
I'm just trying to remove out of the equation Laura, which may or may not be in trouble based on what we heard today, and see what's left. And what I'm hearing is 3 police reports.
That
I take it it's 3 police reports where there appears to be a stop for what in most contexts might be viewed as a de minimis violation, and they happen to be of minorities, correct?
Exactly.
So that is similar. I mean, I understand there's a difference in civil and criminal, but that would be similar to somebody saying, I have other people who came 10 minutes late and they weren't docked for pay, or every time I've got 3 people who were 10 minutes late and they were docked, correct?
Correct.
Well, not exactly.
Well, not exactly, but what I wanted to point out with the New Jersey cases in addition, however, was in the Kennedy case, which is cited in both briefs, the court actually was relying not on the statistics which were alluded to before, which were obtained by the ACLU by observing various drivers on the roads and making all of those notes. The statistics relied upon in Kennedy, which is a pre-trial discovery case, were actually simply a compilation of numbers of defendants taken by the local public defender office. And they said, look, in this year we had this many defendants who were minorities who were stopped for motor vehicle problems. In that same year, we had this percentage of our clients who were charged with any crime were Caucasian, and that was the comparison they did. And the Kennedy court was very critical of that data and said it actually is not good data. But for simply the purpose of obtaining discovery on this issue, it was enough. Defendants should not be put to a test like Lampron in a case like this. These documents are not privileged documents. They're police reports.
The Lampron
Well,
doesn't
Lampron
just
doesn't
relate to
deal
privileged
with
documents.
Well, they're also not documents in the custody of a third party. The only other situation, I mean, there aren't documents around which someone should be able to give the opportunity to come in and assert a privacy right. That's the point, I think, of Lampron and of the other cases.
Oh, no,
You're asking to subpoena records before trial, before there's a hearing, so that you can examine them, so that you can develop the issue for purposes of the hearing or the trial.
Records, yes, but not the same kinds of records.
If you take Lampron itself out of it, I mean, it's, I think what the Commonwealth is arguing is it's really a Rule 17 issue.
And I'm saying it isn't.
It's not a Rule
I'm
17
saying it's
issue?
not. I'm saying, first of all, this trial judge did not view it that way. This trial judge believed that these records had relevance to this case. And it was just these kinds of records that were used in Laura. And again, regardless of how you view the statistics in Laura, it was material that could be used. Then you can take it and compare it to something else.
But the question, I think, is who is the custodian of those records? Is it the prosecutor who has access to information in a particular officer's file that is being developed to prosecute this case?
I would point out,
or is it the repository of the state police who has records in other people's files?
that issue, I would point out, was not raised by the Commonwealth in its appeal before this court in this case. That was raised in the other case. In this case, the only issue raised was relevance and materiality. However, I do believe that those records are in the custody of the Commonwealth. The police, the state police, are agents of the Commonwealth, and I think that they have those documents available in
Well,
their
they're
files.
agents, and for certain purposes, the documents of the agents are deemed to be in the possession custody of the prosecutor. But generally speaking, those are documents produced in the course of an investigation. These are not documents produced in the course of this investigation.
No, they're not, and neither were the police reports. I would cite, my sister mentioned in her argument that she knows of no other case in this or any other jurisdiction where a defendant has obtained in discovery reports from other cases. I can cite one, and it's People versus Corish, which is a case cited by the Commonwealth. That case, 802 Pacific 2nd 278, cites another case called City of Alhambra, 205 Cal App 3rd 1018, which is a contrary case where a defendant was able to get reports from a similar case, and all they had to do was make an assertion and maybe perhaps some showing that there was a similar case.
But isn't that, so in other words, they were able to establish, presumably, relevance?
Relevance.
Right. Well, that's what Rule 17 really requires. Right?
That's right, and Rule 14 requires it. And this judge believed, this judge implicitly found that this defendant had established relevance with his submissions at the hearing, with his briefs, by reference to Laura and Gonzalez. And I assume that reference to Gonzalez was the concurring opinion by Justice Ireland. The fact of the matter is that when this motion was heard, there was no threshold showing requirement. And those requirements are for relatively rare cases in discovery in this Commonwealth. Post-conviction, there's a burden on defendants where they have to come in.
You're suggesting to me there's absolutely no showing required to get this evidence?
No evidentiary showing. In other words, you can't just walk into court and say, Judge, I want this because I want it. You have to establish and you have to persuade the judge that the, that the
What about
material
US?
You've got to say, you've got to make an argument at least about why they're relevant.
Exactly, and he did that. He said, I want to make this argument. I want to make an equal protection argument. Here's how they did it in Laura. They requested these documents, which incidentally they got in Laura, to make those statistics.
But why isn't, but how, I don't, you can make the argument, but why not whenever anybody, minority, no matter what group, is arrested, why can't the same argument be made? I want to make an argument that I have been selectively prosecuted, so I want all of the reports of this police officer, all of the rest the officer has ever made, because I think it might be relevant. Doesn't Armstrong at least say you need some evidence that similarly situated people were not prosecuted in order to get discovery?
I'm glad you mentioned Armstrong, because that case was decided under the federal rules. Very, very different. The federal rules don't even contain the word exculpatory. In our rules here in Massachusetts, we've got a much more expansive view of what exculpatory evidence is.
Well, this
That
clearly
case-
can't be viewed as exculpatory at this point.
Well, I would take issue with that, because if a defendant were able to take this material and use it in support of a motion brought under the equal protection theory, under selective prosecution theory, and got a result that ended the case, that's exculpatory evidence. It's part of the defendant's
But the point
defense.
is, I think that if you got, to use the example that's been used, if you have 3 reports here, and you got 90 others, and 89 of them were of citations of non-minority people, it would not be exculpatory evidence.
No, it wouldn't. And as the single justice pointed out in her order, this material may help the defendant, and it may not. And nobody will know that until the material's turned over.
I'm
But
not
it's in the-
disagreeing with that, but I don't think it's I think it's hard to argue that you're making a request for exculpatory evidence as much as you are for relevant evidence that may seek to go to your defense.
I think that this order can be justified as simply the way it was requested, which is a request for material and relevant reports. That's how the request was made. It was not made as a request for exculpatory evidence, but the argument could be made. In Armstrong, the whole decision was written based on an interpretation of Federal Rule 16, and it talked about how that the meaning of exculpatory evidence there, or something that's relevant to the defendant's defense, is limited to things that can be used to attack the government's case in chief. That's not how this court has ever looked at relevant evidence for a defense, whether you want to call it exculpatory or simply relevant.
Let me ask you this. In this case, aren't we actually looking at what the single justice did
Yes,
as opposed to what the trial judge did?
that's correct.
And isn't our chore to determine whether or not the single justice committed an error of law?
Yes, I think that's exactly what the chore is.
Yes, but if the motion judge committed an error of law and the single justice rubber stamped it, or didn't quite rubber stamp it, but agreed with it, then she's wrong too.
Well, it's 2 levels of the exercise of discretion, and the trial judge may have done something that the wisdom of which could be questioned, but the single justice, exercising her discretion in reviewing the exercise of the trial judge's discretion, may say, well, I may feel different. It may support it, it may not support it, but I think it's close enough to relevant. I think that the defendant satisfied that test, satisfied the motion judge, and the motion judge was free to do this. And the only way that this court would be justified in vacating it would be to find that they both made a very grave error.
Ms. Feldman-Wampler, let me ask you a question. Under our rules, burdensomeness is not one of the required standards. It has to be, is it material and relevant? But let's assume that we conclude that the prosecutor does have custody and control of these records. And let's assume, for purposes of argument, that assembling the records would take many, many, many hours of work to do that, because it would mean going through every single file and copying them. And I don't know how many. It could be 25 stops, or it could be 2,500 stops. Where's an opportunity for the state police to say, you have to take that into account, or should that just not be a consideration?
I think it shouldn't be a consideration because the Commonwealth didn't raise it, and the opportunity for it to be raised was when the defendant filed his motion and the Commonwealth appeared at hearing, argued it, and then filed their opposition.
Thank you.
Thank you, Your Honor.